stipulation?
Well, I really don't have a choice. I can call my office and we can get this done in 2 seconds. I can have someone fax it or drive it up here, Judge, if that's the way we want to do it. I mean, I have resources, so we can do that if I have to do that to make a point. By time it's time to go in, I can have it corrected and have that good morning included in there.
Well, here's the reason I'm asking, because if it's a summary that's in a different format, it may not be cumulative.
Right.
If it's anything else, it's clearly cumulative. It's in the record twice. Mr. Parrish, I don't know what your agreement off the record with opposing counsel was. All I heard was that there was going to be an effort to introduce these exhibits. They were going to be reviewed over the weekend, and I was going to hear more about it on Monday. But I don't know what the two of you discussed outside what I knew. It does appear to me the evidence in question is already all in the record twice. I agree that this format is easier to follow than what is in the record. If there is some issue about whether it is complete, a stipulation that indicates this is a summary of Exhibit 20A, and 20A is the actual evidence, this is a summary, should be sufficient to solve our problems. Even if we didn't let it in as an exhibit, I would definitely let you reference it and put it up in your closing argument, because it's clearly a viable demonstrative and it's just a summary of the evidence. The state is free to point out that it might be missing a phone call. You can point out if you want that the jury should verify everything is there. My guess is that everything that potentially makes much of a difference, with the possible exception of the one call, and I'm not sure how much difference the one text makes, but is probably here.
I'm willing to do that.
So let's go on the record. We're on the record outside the presence of the jury in FECR 108817. The court was apprised off the record earlier this morning that the defendant, pursuant to some discussions late on Friday, wishes to reopen its case in the presence of the jury and offer defendant's Exhibit T2. There has been some discussion that the state is concerned about whether T2 is a complete exhibit and will likely object. Ms. Elliott, would you please state what your objection would be for the record?
Your Honor, the state just received this version of T2 this morning, and we haven't had the opportunity to go through all the messages, but from just a cursory look of the text messages from June 12, 2015, it appears that there is one missing, and I don't know if that's going to tell us what the rest of the document is like, but just we have some concerns about this being a complete record of all the text message communication between Alexander and Andrea. The format is great, it's very readable, no objection with that. We just would like some sort of instruction, if this is going to be admitted as an exhibit, that this may not be a complete summary of every message between the two.
Mr. Parrish, in our off-the-record discussion, I discussed the possibility of a stipulation with you. Would the defendant be willing to enter into a stipulation that Defendant's Exhibit T2 is a summary of the information contained in Exhibit 20A, and that the actual evidence is Exhibit 20A?
Your Honor, we would, but for the record, I'd like to clarify some things. This goes back to about a week-old discussion when we called off some of the witnesses in this case pursuant to an agreement I thought I had with the state with regard to telephone records. I thought I put part of that on the record last Friday when I had discussions about it. In preparing for my closing argument between Thursday and Friday, I went back and I saw that a couple of the from and tos in the effort of preparing the exhibit were out of order. I worked on that along with my staff this weekend to change that around. We brought a cleared version up. I gave it to the state this morning, told them to look at it. I found that the from and tos were not correct. It was the only thing that was in error. Everything else was included in there. This morning, the state indicated they looked at it. The first response was that it looked pretty good. Then they said a good morning was missing, I believe, on June 8th, a good morning might have been missing. I don't know what the issue was, whether it was June 8th or not, but a good morning was missing out of the exhibit. We checked it fairly closely. So that was the record I wanted to make on that. I thought I had an agreement with the state. We did not have to include everything in it, but that the record would reflect the issues we wanted to know. We reformatted it because I thought the state's exhibit was very difficult to read. I thought it was very confusing. I thought that it did not outline as clearly as possible what the conversation was and the course of the conversation in more direct terms. I have no problem with the objection, but I would also want to point out, Judge, their exhibits went in the redacted version without any objection, as I've done consistently through this trial to make this trial a much easier process for the state. I didn't require them to make a single foundation. I could have made this a very difficult trial for the state had I wanted to. I have the experience to do that. But I have let every single exhibit, their leading questions, everything go in the course of this trial. And I find it amazing that at this point in the trial, they would now object to an exhibit because good morning is missing from it. I find that a little astonishing, but I'm prepared to accept this objection. I won't even go back and say on their objection where they submitted the redacted version that that's just a summary. I'm not going to stoop to that level, but I just think it's an unfair thing for the state to do, but if that's the way they want to do it, that's fine.
Well, counsel, based on our off-the-record discussion and what I've heard here, I'm going to allow Exhibit T2, but after the exhibit is offered, I'm going to instruct the jury that Exhibit T2 is a summary. If there is a discrepancy between Exhibit T2 and Exhibits 20A, 20B, and LL, that the jury should rely on 20A, 20B, and LL, and not on the summary. In that event, if the state's concerns hold water and there are things missing, the jury will understand this is only a summary, but this summary is much easier to read than the exhibits the jury has in front of it, and appears to me to condense 100 pages or so of exhibit into about 20-some pages, which will make their deliberations much easier. But I think this will also address any concern the state raised. I'll just tell the jury, if you find a discrepancy, rely on the other exhibits. This is a summary for your use.
Thank you.
That's fine, Judge.
Let's go on to jury instructions if you're both ready. Just set it in the box, I think. One other thing before we go on to instructions, counsel. It's my intent with the exhibits, even though the firearm is disabled, I'm going to send the firearm back to the jury room. I am not going to send back the ammunition box. I will tell the jury that if they want the ammunition box, we'll have the court attendant bring the firearm out and then bring the ammunition box in. I note the ammunition box is sealed and they shouldn't be unsealing it, but that events any possibility that something really weird happens with a gun and ammunition in the jury room. I doubt that something would, but that's the only restriction I'm going to put on their access to the exhibits. I think that's a typical restriction, although often firearms are not as fully disabled as this one is. With regard to the instruction, does the state have any exceptions or objections to the court's proposed instructions?
Your Honor.
Mr. Parrish, does the defendant have any exceptions or objections to the court's proposed instructions?
Your Honor, with regard to, well, let me make this record, Judge. I would say that the court has given us ample opportunity to review the instructions. It prepared preliminary set for us. I've had an opportunity to review them in the presence of our client. We've had an extensive discussion off the record on this case. The court has allowed us plenty of opportunity to submit our proposed instructions on this case, and I believe the court has given us proper review of both sides' proposed instructions. With that in mind, Judge, what we would like to have the court consider, and we would object to instruction number 18. Instruction number 18, obviously, is the elements of the first-degree murder. We believe, Judge, that in light of the law in this area, and that it's still developing law, that the court ought to consider including diminished responsibility as one of the factors that a jury would have to consider. How I would suggest, Judge, that this could be done is that you could take, say, in a number 4, and you could insert in there that a diminished responsibility did not exist. That would be my suggestion, Judge. So we would object to the fact that that was not included. In all fairness to the court's thought on this, it did think about this issue, and it did indicate that it would bring diminished responsibility forward, which we don't object to and think that's a good idea. I'm sorry.
For clarification.
Sure.
Are you arguing with regard to the content of instruction number 3, which governs diminished responsibility, or just with regard to where it falls in the set of instructions?
Where it falls, Judge.
Okay,
Correct.
thank you.
Correct. Thank you. And no, and I did indicate, Judge, we appreciate the fact that the court did move it up in its consideration. We also think, Judge, since, and I'm sure the committee studied this quite a bit, or may have even thought about it at some point, but we think specific intent, and that's instruction, I can't put my finger on it. The specific intent instruction, 22, thank you, Judge, should include a reference to diminished responsibility. And that should have included at the end of the sentence, that the sentence would say that diminished responsibility did not exist. Judge, other than those 2 points, we would like to say that we would have no objections, no additions, or no other matters to speak of with regard to the instructions, and find them very acceptable.
Thank you, Mr. Parrish. The court overrules the defendant's exceptions and objections. I do want to make doubly sure, I think we've already made a record, but I'll reference back. We previously made a record outside the presence of the jury that the defendant, based on professional statement of counsel and his endorsement of same, has agreed that the court need not instruct on lesser included offenses below the level of involuntary manslaughter, in large part because of the defense theory in this case. Is that accurate, Mr. Parrish?
That is accurate. The court
Cautionary instruction was already given before the evidence is referenced in closings. The jury will have the advantage of having had all the terms defined for it in the instructions, and will be in the position of putting the evidence in the context of the instructions. The court also wants counsel to understand that I will give a preliminary statement prior to closings, reminding the jury that closing arguments are not evidence. And I believe those things together, although I appreciate the defendant's concern, will be adequate to protect the defendant's interests. The court would note that it has exercised some caution in using whatever discretion it may have here, because I do want to be sure that we have given the defendant as fair a trial as is possible. And this is one of the few issues that has come up during the trial that the court has felt need to be carefully addressed. I also want to tell counsel that I appreciate but for your discrepancies about Exhibit T2. The very professional way the two sides have presented this case, really since the inception of the case, you've acted very cooperatively. You've tended to fight about those issues that actually make a difference in the case or might make a difference in the case. Neither side had to take that approach, but I very much appreciate the approach. I think Mr. Kozak has actually been very well served by that approach, in that now the case is focused in on the issues that might make a difference versus a bunch of collateral issues that wouldn't. And certainly from my perspective, you have minimized how much time I have to invest in this case so that I can focus on what's really important and not focus on a bunch of other things. And so I wanted to express my gratitude to both sides for doing that. Mr. Kozak, you don't have to believe me. I don't expect you to respond. You've been extremely well represented in this case. I don't think you could have found somebody to do a better job than Mr. Parrish has done for you. I don't know what difference, if any, that will make in the outcome of the case, but I think Mr. Parrish has done an exceptional job on your behalf handling this case, and you should be happy with him. Anything further, counsel, we need to put on the record at this point?
Do you mind if I continue sitting up there?
No, go ahead.
Okay.
As I suggested earlier, if the jury is ready early, we might start a few minutes early, but I need to know that you're ready before I can bring them in. And I don't know if they're here or not, but I'll find out.
Al, you're going to need T2 back too, aren't you?
I'm all done with it, Judge. I don't think that was your copy, but.
Oh, this is my copy?
Yeah, sure.
Oh, okay, all right.
Thank you.
Thank you. I thought maybe it was an original.
Oh, no. We're good. We have one that can, go ahead, let's go.
And we do, as I understand it, at least the state's exhibits, we squared those away Friday. What about the defense exhibits with the exception of T2? Are they all together now in the box?
Right here.
There's LL and T, there, we went through the list Friday, but I don't know if we made sure that we've just got the defense exhibits in the box. Let's make sure we've got that.
Okay, here in there, judges, LL, MM.
Okay.
So that's Margaret. This is close.
All right. The Sauter District Court is reconvened. The Honorable Judge Christopher Burns presiding.
Please be seated. Mr. Parrish, do you have a matter you wish to address?
Yes, Your Honor, we would move to offer Exhibit T2.
So, ladies and gentlemen, the defendants moved to reopen this case to offer this exhibit. I am granting that motion to reopen the defense case. My understanding is there's an objection to Exhibit T2. Is that correct, counsel?
Yes, Your Honor.
And is that the objection I previously heard on the record?
Correct.
The court overrules the objection to Exhibit T2. Exhibit T2 is admitted. I need the jurors to understand T2 is a summary of the information already contained in Exhibits 20A, 20B, and LL. If you find a discrepancy between Exhibit T2 and Exhibits 20A, 20B, and LL, you should rely on Exhibits 20A, 20B, and LL, and not on Exhibit T2 if you find a discrepancy. That said, any further evidence at this time from the defendant, Mr. Parrish?
No, Your Honor, thank you.
Ladies and gentlemen, at this point in the trial, I will read you the jury instructions we have prepared. Counsel will then do their closing arguments. I will dispense with reading the numbers of the instructions because it actually adds a few minutes to the total length. This is State of Iowa versus Alexander Matthew Kozak. You have with you some copies of these instructions. If you would like to look along, you have to share. We try not to cut down too many trees. I think those of you who are on this end will have to share 3 to 1, and the other should be 1 for every 2 people. Again, this is State of Iowa versus Alexander Matthew Kozak, Johnson County case FECR 108817. The trial information accuses the defendant of the crime of murder in the first degree in that Alexander Matthew Kozak, the defendant herein, on or about July 12, 2015, in Johnson County, Iowa, did, having malice aforethought, willfully, deliberately, and with premeditation, kill Andrea Farrington, to wit, the defendant approached Andrea Farrington at the Coral Ridge Mall and shot her 3 times, killing her. Murder in the first degree includes the lesser crimes of murder in the second degree, voluntary manslaughter, and involuntary manslaughter. To these charges, the defendant has entered a plea of not guilty. Upon the issues thus made, you are instructed as follows.
Your Honor, just a second. I believe you said July 12.
Sorry, it's June 12. Also, you will have my original set of instructions back in the jury room to reference during your deliberations. Instruction number 1. The trial information charges the defendant, Alexander Matthew Kozak, with the crime of murder in the first degree. The trial information includes charges of the lesser degrees of murder in the second degree, voluntary manslaughter, and involuntary manslaughter. Alexander Matthew Kozak has entered a plea of not guilty. The plea of not guilty is a complete denial of the charge and places the burden on the state to prove guilt beyond a reasonable doubt. Whenever I instruct you the state must prove something, it must be by evidence beyond a reasonable doubt. If the state does not prove the defendant guilty beyond a reasonable doubt, your verdict must be not guilty. You must determine the defendant's guilt or innocence from the evidence and the law in these instructions. You must consider all of the instructions together. No one instruction includes all the applicable law, and you should attach no significance to the order in which they are given. Do not be influenced by any personal likes or dislikes, sympathy, bias, prejudices, or emotions. The trial information is the document that formally charges the defendant with the crime and is merely the method by which the defendant is brought into court for trial. It is not evidence. The defendant is presumed innocent and not guilty. This presumption of innocence requires you to put aside all suspicion which might arise from the arrest, charge, or the present situation of the defendant. The presumption of innocence remains with the defendant throughout the trial unless the evidence establishes guilt beyond a reasonable doubt. The burden is on the state to prove defendant guilty beyond a reasonable doubt. A reasonable doubt is one that fairly and naturally arises from the evidence in the case or from the lack or failure of evidence produced by the state. A reasonable doubt is a doubt based upon reason and common sense, the kind of doubt that would make a reasonable person hesitate to act. Proof beyond a reasonable doubt, therefore, must be proof of such a convincing character that a reasonable person would not hesitate to rely and act upon it. However, proof beyond a reasonable doubt does not mean proof beyond all possible doubt. If, after a full and fair consideration of all the evidence, you are firmly convinced of the defendant's guilt, then you have no reasonable doubt, and you should find the defendant guilty. But if, after a full and fair consideration of all the evidence in the case, or from the lack or failure of evidence produced by the state, you are not firmly convinced of the defendant's guilt, then you have a reasonable doubt, and you should find the defendant not guilty. You shall base your verdict only upon the evidence in these instructions. Evidence is testimony in person, exhibits received by the court. You may examine the exhibits closely, but be careful not to alter or destroy them. Stipulations, which are agreements between the attorneys. Facts may be proved by direct evidence, circumstantial evidence, or a combination of both. Sometimes during a trial, references are made to pretrial statements and reports, witnesses' depositions, or other miscellaneous items. Only those things formally offered and received by the court are available to you during your deliberations. Documents or items read from or referred to which were not offered and received into evidence are not available to you. The following are not evidence: statements, arguments, questions, and comments by the lawyers, objections and ruling on objections, any testimony I told you to disregard, anything you saw or heard about this case outside the courtroom. In considering the evidence, make deductions and reach conclusions according to reason and common sense. Facts may be proved by direct evidence, circumstantial evidence, or both. Direct evidence is evidence from a witness who claims actual knowledge of a fact, such as an eyewitness. Circumstantial evidence is evidence about a chain of facts which show a defendant is guilty or not guilty. The law makes no distinction between direct evidence and circumstantial evidence. Give all the evidence the weight and value you think it is entitled to receive. Decide the facts from the evidence. Consider the evidence using your observations, common sense, and experience. Try to reconcile any conflicts in the evidence, but if you cannot, accept the evidence you find more believable. In determining the facts, you may have to decide what testimony you believe. You may believe all, part, or none of any witness's testimony. There are many factors which you may consider in deciding what testimony to believe. For example, whether the testimony is reasonable and consistent with other evidence you believe, whether a witness has made inconsistent statements, the witness's appearance, conduct, age, intelligence, memory, and knowledge of the facts, the witness's interest in the trial, their motive, candor, bias, and prejudice. Nothing I have said or done during the trial was intended to give any opinion as to the facts. There's a typo there, it says facts. Proof or what your verdict should be. If there is a reasonable doubt as to the degree of the crime, the defendant shall only be convicted of the degree for which there is no reasonable doubt. The duty of the jury is to determine if the defendant is guilty or not guilty. In the event of a guilty verdict, you have nothing to do with punishment. Where two or more alternative theories are presented, or where two or more facts would produce the same result, the law does not require each juror to agree as to which theory or fact leads to his or her verdict. It is the verdict itself which must be unanimous, not the theory or facts upon which it is based. It is proper for an attorney to interview any witness in preparation for trial. You have heard testimony from persons described as experts. Persons who have become experts in a field because of their education and experience may give their opinion on matters in that field and the reasons for their opinion. Consider expert testimony just like any testimony. You may accept or reject it. You may give it as much weight as you think it deserves, considering the witness's education and experience, the reasons given for the opinion, and all the other evidence of the case. Evidence has been offered to show that the defendant made statements at an earlier time and place. If you find any of the statements were made, then you may consider them as part of the evidence, just as if they had been made at this trial. You have heard evidence claiming one or more witnesses made statements before this trial while not under oath, which were inconsistent with what the witness said in this trial. Because the witness did not make the earlier statements under oath, you may use them only to help you decide if you believe the witness. Decide if the earlier statements were made and whether they were inconsistent with testimony given at trial. You may disregard all or any part of the testimony if you find the statements were made and they were inconsistent with the testimony given at trial, but you are not required to do so. Do not disregard the testimony if other evidence you believe supports it, or if you believe it for any other reason. At this point, I'll start giving you the instruction numbers because we start referencing various instructions by number. Instruction number 18. The state must prove all of the following elements of murder in the first degree. On or about the 12th day of June 2015, the defendant shot Andrea Farrington. Andrea Farrington died as a result of being shot. The defendant acted with malice aforethought. The defendant acted willfully, deliberately, premeditatedly, and with specific intent to kill Andrea Farrington. If the state has proved all of the elements, the defendant is guilty of murder in the first degree. If the state has failed to prove any one of the elements, the defendant is not guilty of murder in the first degree, and you will then consider the charge of murder in the second degree explained in instruction number 28. Instruction number 19. Concerning element number 2 of instruction number 18, the wound inflicted by the defendant resulted in death of Andrea Farrington if it caused or directly contributed to Andrea Farrington's death. Instruction number 20. Concerning element number 3 of instruction number 18. Malice is a state of mind which leads one to intentionally do a wrongful act to the injury of another or in disregard of the rights of another out of actual hatred or with an evil or unlawful purpose. It may be established by evidence of actual hatred or by proof of a deliberate or fixed intent to do injury. It may be found from the acts and conduct of the defendant and the means used in doing the wrongful and injurious act. Malice requires only such deliberation that would make a person appreciate and understand the nature of the act and its consequences, as distinguished from an act done in the heat of passion. Malice aforethought is a fixed purpose or design to do some physical harm to another which exists before the act is committed. It does not have to exist for any particular length of time. Malice aforethought may be inferred from the defendant's use of a dangerous weapon. A dangerous weapon is any device or instrument designed primarily for use in inflicting death or injury, and when used in its designed manner is capable of inflicting death. It is also any sort of instrument or device actually used in such a way as to indicate the user intended to inflict death or serious injury, and when so used is capable of inflicting death. You are instructed that a gun is by law a dangerous weapon. Instruction number 22. As it regards paragraph number 4 of instruction number 18, specific intent means not only being aware of doing an act and doing it voluntarily, but in addition, doing it with a specific purpose in mind. Because determining the defendant's specific intent requires you to decide what he was thinking when an act was done, it is seldom capable of direct proof. Therefore, you should consider the facts and circumstances surrounding the act to determine the defendant's specific intent. You may, but are not required to, conclude a person intends the natural results of his or her acts. Instruction number 23. Diminished responsibility means a mental condition which does not allow the person to form a premeditated, deliberate, specific intent to kill. Diminished responsibility does not entirely relieve a person of the responsibility for his or her actions and is not the same as an insanity defense. You should determine from the evidence if the defendant was capable of premeditating, deliberating, and forming a specific intent to kill. If you have a reasonable doubt the defendant was capable of acting deliberately with premeditation and the specific intent to kill, then the defendant cannot be guilty of first-degree murder. You should then consider the lesser included charge of murder in the second degree as explained in instruction number 28. Instruction number 24, concerning element number 4 of instruction number 18. Willful means intentional or by fixed design or purpose and not accidental. To deliberate is to weigh in one's mind, to consider, to contemplate, or to reflect. Premeditate is to think or ponder upon a matter before acting. Instruction number 25, concerning element number 4 of instruction number 18. Deliberation and premeditation need not exist for any particular length of time before the act. Instruction number 26. If a person has the opportunity to deliberate and uses a dangerous weapon against another resulting in death, you may, but are not required to, infer that the weapon was used with malice, premeditation, and the specific intent to kill. Instruction number 27. As it regards the lesser included charges explained in instruction numbers 28, 30, and 32, to commit a crime, a person must intend to do an act which is against the law. While it is not necessary that a person knows the act is against the law, it is necessary that the person was aware he or she was doing the act, and he or she did it voluntarily, not by mistake or accidental. You may, but are not required to conclude a person intends the natural result of his or her acts. Instruction number 28. The state must prove all of the following elements of murder in the second degree. 1. On or about the 12th day of June 2015, the defendant shot Andrea Farrington. 2. Andrea Farrington died as a result of being shot. 3. The defendant acted with malice aforethought. If the state has proved all the elements, the defendant is guilty of murder in the second degree. If the state has failed to prove any one of the elements, the defendant is not guilty of murder in the second degree, and you will then consider the charge of voluntary manslaughter explained in instruction number 30. Instruction number 29. Murder in the second degree does not require a specific intent to kill another person. Instruction number 30. The state must prove all of the following elements of voluntary manslaughter. 1. On or about the 12th day of June 2015, the defendant intentionally shot Andrea Farrington. 2. Andrea Farrington died as a result of being shot. 3. The shooting was done solely by reason of sudden, violent, and irresistible passion resulting from serious provocation. If the state has proved all of the elements, the defendant is guilty of voluntary manslaughter. If the state has failed to prove any one of the elements, the defendant is not guilty of voluntary manslaughter, and you will then consider the charge of involuntary manslaughter explained in instruction number 32. Instruction number 31. Concerning element number 3 of instruction number 30, a serious provocation is conduct that would cause a reasonable person to have a sudden, violent, and irresistible passion. Passion is not sudden, violent, and irresistible if there is an interval of time during which a reasonable person would, under the circumstances, have time to reflect and bring his passion under control and suppress the impulse to kill. Words alone, however abusive or insulting, cannot be serious provocation. Instruction number 32. The state must prove all of the following elements of involuntary manslaughter. Number 1, on or about the 12th day of June 2015, the defendant recklessly fired a gun toward Andrea Farrington in a crowded mall. 2, when the defendant committed the crime, the defendant unintentionally caused the death of Andrea Farrington. If the state has proved both the elements, the defendant is guilty of involuntary manslaughter. If the state has failed to prove either of the elements, the defendant is not guilty of involuntary manslaughter. Instruction number 33. As it regards paragraph number 1 of instruction number 32, a person is reckless or acts recklessly when he willfully disregards the safety of persons or property. It is more than a lack of reasonable care which may cause unintentional injury. Recklessness is conduct which is consciously done with willful disregard of the consequences. For recklessness to cease, the act must be highly dangerous. In addition, the danger must be so obvious that the actor knows or should reasonably foresee that harm will more likely than not result from the act. Though recklessness is willful, it is not intentional in the sense that harm is intended to result. Instructed number 34. The defendant cannot be convicted by a confession alone. There must be other evidence the defendant committed the crime. In determining the weight and believability of the confession, you should consider 1. Defendant's mental capacity and intelligence. 2. Defendant's mental and emotional state at the time it was made. 3. Whether it was knowingly and intelligently made. 4. Whether the defendant understood it. 5. Any other evidence relating to the confession. Instruction number 35. During the trial, you have been allowed to take notes. You may take these with you to the jury room to use in your deliberations. Remember, these are notes and not evidence. Generally, they reflect the recollection or impressions of the evidence as viewed by the person taking them and may be inaccurate or incomplete. Upon reaching a verdict, leave the notes in the jury room and they will be destroyed. You shall not alter or mark upon the exhibits in any way. Upon reaching a verdict, leave the exhibits in the jury room and they will be collected by the court attendant. The verdict form must be filled out and signed in ink. You shall not alter or mark upon the original jury instructions except to complete and sign the verdict form. Upon reaching a verdict, the court attendant will collect the jury instructions and verdict form from you. Instruction number 36. You may not communicate about this case before reaching your verdict. This includes cell phones and electronic media such as text messages, Facebook, LinkedIn, Snapchat, Instagram, YouTube, Twitter, Yik Yak, email, etc. Do not do any research or make any investigation about this case on your own. Do not visit or view any place discussed in this case, and do not use internet maps or Google Earth or any other program or device to search for or to view any place discussed in the testimony. Do not view, read, or listen to any media accounts of this trial. That says trail, and it should say trial. Or the events at issue in this case. Also, do not research any information about this case, the law, or the people involved, including the parties, the witnesses, the lawyers, or the judge. This includes using the internet to research events or people referenced in the trial. This case must be tried on evidence presented in the courtroom. If you conduct independent research, you will be relying on matters not presented in court. The parties have a right to have this case decided on the evidence they know about and that has been introduced here in court. If you do some research or investigation or experiment that we do not know about, then your verdict may be influenced by inaccurate, incomplete, or misleading information that has not been tested by the trial process, including the oath to tell the truth and by cross-examination. All of the parties are entitled to a fair trial rendered by an impartial jury, and you must conduct yourself so as to maintain the integrity of the trial process. If you decide a case based on information not presented in court, you will have denied the parties a fair trial in accordance with the rules of the state, and you will have done an injustice. It is very important that you abide by these rules. Failure to follow these instructions may result in the case having to be retried and could result in you being held in contempt and punished. It is important that we have your full and undivided attention during the remainder of this trial and the jury deliberations. Instruction number 37. When you begin your deliberations, you should select a foreman or forewoman. He or she shall see that your deliberations are carried on in an orderly manner, that the issues are fully and freely discussed, and that every juror is given an opportunity to express his views. In order to return a verdict, each juror must agree to it. Your verdict must be unanimous. It is your duty as jurors to consult with one another and reach an agreement if you can do so without compromising your individual judgment. Each of you must decide the case for yourself, but do so only after an impartial consideration of the evidence with the other jurors. During your deliberations, do not hesitate to re-examine your view and change your opinion if convinced it is wrong. But do not change your opinion as to the weight or effect of the evidence just because it is the opinion of the other jurors or for the mere purpose of returning a verdict. Remember, you are judges of the facts. Your sole duty is to find the truth and do justice. Instruction number 38. Occasionally after a jury retires to the jury room, the members have questions. I have prepared the instructions after carefully considering this case with the parties and lawyers. I have tried to use language which is generally understandable. Usually your questions about the instructions can be answered by carefully rereading them. If, however, you feel it necessary to ask a question, you must do so in writing. I cannot communicate with you without first discussing your question and potential answer with the parties and the lawyers. The court attendant who has been working with me on this case is in the same position as I am. She takes an oath not to communicate with you about the substance of the case.
She should not speak to you except to ask if you have agreed upon a verdict and to manage the logistics of your service. Please do not put her on the spot by asking any questions about the instructions or the evidence. Jurors like to know how long they will deliberate each day. Normally, I leave that up to you. Please notify the court attendant in writing how long you would like to work and how early you would like to reconvene if that is necessary. Finally, if you need to notify anyone about the time you will be deliberating, please notify the court attendant and we will make a phone available to you. Before you enter the jury room, give your cell phones to the court attendant for safekeeping. Cell phones are not allowed in the jury room. The cell phones will be returned to their owners when the jury deliberations are concluded or when you leave the courthouse for the day. I will read you instruction number 39 and go over the verdict forms with you after the closing arguments have been completed.